Introduction for application of Uruf. In Malaysia courts, the use of Uruf pertains to the practice of local customs and tradition as evidence or arguments in legal proceedings. Uruf represents the societal norms, traditions and accepted behaviors within specific communities, which courts may consider to understand local standards or interpret legal matters within their societal norms. Uruf in Malaysia courts emphasizes the importance of customary practices and local traditions in influencing legal decisions. Court involves recognizing Uruf to understand wider cultural context, interpret laws, and resolve disputes by integrating prevalent societal norms and customs among diverse communities across the country. At its core, Uruf represents the established or widely accepted practices ingrained within a specific community. These practices can encompass a vast spectrum of social interaction, from familial customs governing marriage and inheritance to economic norms in business transactions and even ethical principles guidance daily conduct. The significance of Uruf lies in the ability to reflect lived realities of a community, often supplementing or even reflecting the legal pronouncements.
Good morning, Professor Dr. Muhammad Azam. I'm Tan Wei Ling. I would like to present about the application of Uruf by the Shariah court in Malaysia in the aspect of contract and commercial matters. Firstly, application of Uruf that is more common is regarding the sikha, offer and acceptance in a muamalah transaction, as well as the right of qiyah, which is the rights to proceed or make a revocation in a sale and purchase agreement. In the past, the Muslim scholars has set the indication of rela in the form of sikha or speech that known as ijab offer and qabul acceptance. However, with the evolution that have been occurred nowadays, the element of like for like taraqi have replaced the usage of ijab and qabul in the older days. Generally, urf can be divided into two types, which are valid urf and invalid urf. Valid urf must practice based on the time of the transaction, which means that an outdated and extinct urf, which is the customary practices, cannot be used anymore in the present time of transaction. In the case of Nur Asma binti Sohari against Radwan bin Cheros, concept of uruf in contract and commercial have been applied. In this case, the applicant applied for a committal order against respondent on his basis of his failure to enforce his promise to bribe the applicant's house. This issue arose was on the amount owed by the respondent to the applicant, as was whether the value of the house should be based on the market value or based on the prior agreement. Applicants have argued this fact in accordance with the community's uruf fili in the sale and purchase process. In this case, any party enters into an agreement to sell and buy a product without a statement of price determination, then the goods will be purchased based on the current price and not during the agreement. Moreover, a sale and purchase transaction involving real estate or an immovable property is inherently dynamic. Thus, it is impossible to set a price for the asset that is static. Eventually, the court accepted the applicant's arguments in this case, which is regarding the application of uruf in the contract and commercial agreement, meaning to say that the court also take into account of the evolution of current price compared to the prior price fixed before. It is due to the prior price does not represent the absolute price of the house. Thus, this case clearly stipulates and studied regarding the concept and principle of uruf that have been applied in the Shariah court in Malaysia. To conclude, the uruf custom is normally considered as a good practices to Muslims and is acceptable as long as it did not against the Islamic teachings and Shariah rulings. And that's all from me. Thank you very much.
Assalamualaikum warahmatullahi wabarakatuh. I am Irdina Sofia binti Azman with metric number 302320, and I am going to explain application of uruf in Islamic banking and finance. The integration of uruf, denoting customary practices in society, significantly influences Malaysia's Islamic banking and finance sector, molding various financial dealings. By embracing uruf, financial institutions tailor products that resonate with locals, promoting wider acceptance of Islamic financial offerings. Hibah, a term rooted in Islamic finance and inheritance law, signifies the act of giving or transferring ownership without any consideration. It is regarded as a Shariah contract, promoted as an act of charity in line with Quranic and prophetic teachings. For hibah to adhere to Shariah principles, specific conditions must be met, encompassing legality, ownership, transferability, and non-association with the giver's property. Hibah spans two categories: wealth management and financial instruments offered by Islamic institutions, often utilized as a tool within Islamic financial system. In the Islamic banking framework, hibah is commonly linked with deposit accounts, originating from the wadi'ah contract. Initially devised as a means to safeguard depositors' fund, wadi'ah evolved into wadi'ah yad damanah, leading banks to grant hibah as an expression of gratitude towards depositors. Nevertheless, varied opinions surfaced among Islamic entities such as SAC of Bank Negara Malaysia, AAOIFI, and Dalah Al-Baqarah regarding hibah's implementation. While some Section 8 under specific conditions, others caution against its habitual practice, fearing potential conflicts of interest and disputes. In Malaysia, the habitual practice of hibah created misconceptions perceived as an attempt to win favour for Islamic banking acceptance. To rectify this, Bank Negara Malaysia issued guidelines banning wadi'ah-based deposit products and necessitating transparency to customers about receiving hibah. The case of tabung haji faced Shariah disputes over hibah distribution to depositors, misconstruing hibah as an annual return conflicting with its original intent. To address this, tabung haji transitioned from wadi'ah to wakalah, realigning the relationship between depositors and tabung haji through an agency agreement. Since wadi'ah concept has been declared based on cards, which is loans, any loans that go against this concept and eventually gain extra advantages from it, it would be definitely considered as riba. Riba is an unlawful act that contradicts with Shariah rulings. Any forms of hibah, wadi'ah, and wadi'ah yad damanah should be not involving any element of riba, or else, with no doubt, it becomes uruf fasid. From this issue that arise by Bank Negara Malaysia, their action of setting a guidelines of card definitely a good move to be done in order to avoid this practice that may become uruf fasid, which is void and invalid among Islamic banks. This type of uruf application indeed not only widen the perspective of uruf itself, but also towards how to apply uruf to avoid uruf fasid. In a sense, this study underscores the adaptability of uruf and its conditions in shaping Islamic finance, ensuring compliance with Shariah principles and serving as a guideline to rectify discrepancies. That's all from me. Thank you.
Hello everyone, I'm Sofang Hui, and today I will talk about application of Uruf in Shariah courts in Malaysia about property matter. First of all, every individual, including husband and wife, has the right to own any property because the Islamic marriage does not deny or limit that right. Besides, Islam considers matrimonial property as a way of recognizing the property that can be owned by a person based on his effort. To own the property, which the words of Allah in Surah Al-Nisa, verse 32. Furthermore, in marital property claims, the property claim can be applied in Shariah courts in three situations, which are claim before marriage, claim after divorce, and also claim after death. For claim before marriage, it generally refers to the concept of dowry. It is a mandatory payment or gift from the grooms to the bride. It acts as a form of financial security for the bride in case of the divorce or death of the husband. Besides, the specific amount and nature of the dower are agreed upon mutually between the bride and groom during the marriage contract negotiations. For claim after divorce, mutua, which is a compensation given by husband to woman due to divorce, and Section 56 of Islamic Family Law Act 1984 specifically provide that such compensations. The amount given is based on mutual agreement. However, in the event the party cannot agree on the amount, then a Shariah judge will decide. Muslim women have the right to the division of matrimonial property, which property are accurate during the marriage. It is undeniable that women contribute direct or indirect to the well-being of her family and even help in raising her family wealth and status in society. A Shariah judge will determine to what extent the sponsors contribute to the acquisition of property during marriage. For claim after death, the Selangor State Fatwa Committee on 18 April 2005 has decided first, matrimonial property after the death of one of party in a marriage in the state of Selangor can be divided between the husband or wife before the marriage, including after the deceased responsibility are released. In the case of Aziza binti Musa versus Muhammad Kamal and Raja Kumaru bin Abdullah, the plaintiff claimed a house in Tamang Desa as matrimonial property after they are married. The defendants counterclaim a house in Rawang and Kancher vehicle. One of the issues is whether the property were accurate or obtained together during their marriage. The court determined that the property in Taman Desa was matrimonial property, while the property in Rawang was not. The Kancher vehicle will also consider matrimonial property.
Good day, everyone. My name is Kanageshwari Jagadesan, and I'm here today to explain the implementation of Uruf in Islamic criminal law. First and foremost, what is Uruf? Well, one notable medium of support for Sharia law is Uruf, or customary law, also known as conventional law. This is illustrated through various Uruf-based legal rulings, ahkam, in Islam. The implementation of Uruf can be seen in every division of the Islamic law, which also includes the Islamic criminal law. Now let's move on to the use of Uruf. The regulations ought to be modified if the custom of a country is different from another or if the tradition from a bygone era has evolved. Islam permits decisions to be made on the basis of custom in situations when there is no clear text, no exact limit on the text applicability, or no consensus over the text interpretation. If Uruf complies with the text, it must be enforced because in such cases, the text is being followed and Uruf is merely a guide. There are also times when someone is brought before the court for a prior crime, and if the crime includes a custom that is no longer in use, and if the accused acknowledges that the crime was performed in line with the past Uruf, the accused will be assessed based on the past Uruf rather than the current custom. Now let's look at a case scenario. To give an idea, if a man confesses to stealing £100 roughly 20 years ago, but the worth of the currency has evolved since then, his acknowledgement of guilt means that the penalty he receives will be determined by the pound's worth at the moment he stole it. This is due to the fact that it is a creative and emergency custom. The customs and cultures of people define the nature of crimes that are not expressly mentioned in the text. Among these practices are the penalties, which are typically arbitrary and prescribed by law to address crimes in the sake of public safety and security when a crime's characteristics are specified, but the customs of the populace at the time are taken into account. Moreover, there are other instances in which texts specify the penalty in advance, leaving it up to custom to ascertain which legal conditions must be satisfied for such actions to be classified as criminal. An example of this would be money taken from a heavily guarded location. Before an accused person is arraigned, the location and amount of the evidence will need to be taken into account. There are also situations when texts ordain the punishment but let custom determine what legal conditions must be satisfied before such actions are considered criminal. This saying by Al-Karafi explains that if a decision is made based on custom, it may be modified if the custom shifts. Furthermore, people's needs evolve over time, which is why laws based on customs and culture must adapt as well. Laws that are designed to be static will make people's lives difficult and restrictive. However, in Islamic law, there are specific situations that are temporarily authorized to change rulings and fall under situations of necessity and needs brought on by hardships. One such example is when Umar ibn al-Khattab suspended the theft penalty during a drought. Now let's look at the implementation of Uruf in the Malaysian judiciary system. Malaysia is renowned for using Islamic law in the local legal system. It has a wide scope of jurisdiction in matters involving banking and finance, contract, commercial, land, and property. However, unlike Saudi Arabia, which constructively associates Sharia law to national law, Malaysia only partially implements the system. Sharia law in Malaysia is restricted to issues of personal and family law such as child custody and marriage, and it only applies to Muslims who account for 61.3% of the nation's population. The judiciary system extremely limited application of Uruf is also relevant. As the majority of cases are decided using civil procedures, particularly those involving criminal offences, in some cases, Uruf is not applied at all, and it is because many decisions, including those that have nothing to do with custom, are unexchangeable. Examples of such decisions include the number of lashes meted out to an adulterer convicted of the crime and punishment for theft, where the crime is proven through evidence. Stated differently, a fixed punishment is immutable. Fixed punishments only seem to alter when they were abandoned due to legal technicalities, like when there is a question about the veracity of the accusation or when it became necessary. As mentioned before, some penalties and also punishments are unchangeable and they are fixed. So the application of Uruf brings no changes. In the case of Pandakwa Shari versus Muhammad Fazil bin Yusuf and another in the year of 2013, both the accused were prosecuted for khalwat or close proximity under Section 31A of the Sharia Criminal Offences under Takze Terengganu Enactment 2001. It was discovered that they had been lodging together in the Fire and Rescue Academy quarters in Marang, Terengganu. It gave rise to a plausible suspicion that they were involved in unethical behavior. Both the accused persons were pleaded guilty of the charges. The court then imposed a sentence of 2,600 ringgit in fine or 3 months in jail if not paid on the accused male. It is clear that in this instance, Uruf is not used. Anyone found to have committed khalwat will, in accordance with Aceh's customs, be married by pemangku adat or traditional authority and will also be required to pay customary diyat. We refer to the union that arises from khalwat as a khalwat marriage. It is evident that different decisions are made in accordance with Aceh's customs and Malaysian legal frameworks. In short, it is obvious that the custom is given precedence in criminal law under Islamic law. This is so because Islamic law addresses society which is dynamic. However, Uruf is not implemented in the deciding of criminal cases in courts of Malaysia. That is all from me. Thank you.
Meaning custom in Arabic is a concept in Islamic law that refers to local custom and practices that are not explicitly mentioned in the Quran or Sunnah. In family law, uruf can be used to supplement and interpret Islamic law, and it can also be used to create new rules of law. Here are some examples of how uruf has been applied in family law cases. First, establishing the right of guardianship. Guardianship of children is typically given to a father after a divorce. However, uruf can be used to give guardianship to the mother if she is deemed to be more fit and capable. The application of uruf in child custody. within Malaysian Shariah courts involve balancing respect for local customs with adherence to the overreaching principles of Islamic law and the best interests of child. Shariah courts may consider uruf if it doesn't conflict with fundamental Islamic principle, and also if it is well established and widely recognized in the relevant community and promotes the child's well-being and best interests. The application of uruf relating to child custody can be seen in the case of Gandhi versus Farah. The complainant Padmanathan, the husband, and the accused Indira Gandhi, the wife, were married and had 3 children. Her husband converted to Islam in March 2009. In April 2009, her husband received certificates of conversion to Islam for all 3 children issued by the State of Pengarah Jabatan Agama Islam Perak and an amicable interim custody order for the children. In September 2009, he obtained a permanent custody order from a Sharia court. In 2013 and 2014, his mother filed a unilateral conversion and custody decision by a Sharia court that granted equal rights to her parents, citing religious upbringing and the minor's child's religion being subject to international law. Obtained a Supreme Court order reversing the decision. Human rights principle, particularly the Convention on the Rights of Children (CRC) and the Convention on the Elimination of All Forms of Discrimination Against Women. The first appeal in this case concerned the legitimacy of the children's conversion to Islam. The majority of the Court of Appeal allowed the husband's appeal and ruled that Sharia court had exclusive jurisdiction to determine the validity of the child's conversion to Islam. When addressing the question of whether a conversion violates international norms, the court noted that an international treaty does not form a part of domestic law unless its provision has been incorporated into domestic law, and the Supreme Court approved. He emphasized that it adheres to strict international standards. The interpretation of federal court does not entail to establish constitutional interpretation principles. As a result, the Court of Appeal did not rule that the children's conversation were invalid. The federal court overturned the lower court's decision. Court of Appeal decision, reasoning that the children did not meet the statutory requirements for conversion. The court specifically found that the children did not state the 2 clauses of the affirmation of faith in Arabic as required by the Para Enactment for a valid conversation to Islam. Furthermore, the federal court ruled that mothers have parental rights equal to fathers, so religious conversation of a child needs the consent of both parents. Traditionally, uruf in certain Malay communities might emphasize the father's primary role in family decision, potentially influencing arguments about Padmanathan's unilateral conversion of the child. However, uruf also recognizes the importance of maternal influence and involvement, which supported Indira's claim to equal say in the children's religious upbringing. To proceed to the second example is the determining of the amount of dower, known as mahir. Mahir is an important component of a Muslim marriage. As mentioned in the Quran and Hadith of the Prophet Muhammad, mahir is given by a man to his wife as a matter of her right. Mahir is a marriage gift from a man to his wife that becomes her sole property in Islam. It is also assigned to show a respect to the wife, except in certain circumstances. If the mahir is not paid during the marriage, the right to mahir survives divorce. Because the amount of mahir is not specified in Islamic law, uruf is frequently used to determine what is considered fair and customary. To conclude our topic, uruf, the Arabic term for custom and common practice, occupies a unique and dynamic space in the tapestry of Islamic law. It stands as a bridge between the timeless principle of Sharia and the ever-evolving realities of society. While its application is not without its challenges, it remains a crucial tool for navigating the complexities of human interaction and ensuring the continued relevance of Islamic jurisprudence. Uruf's strength lies in its ability to adapt. Unlike the rigid confines of codified law, uruf allows for flexibility responding to the changing needs and circumstances of communities. This dynamism is particularly evident in areas such as: first, contractual obligation. Uruf can fill in gaps where explicit legal texts are silent, defining customary practices and expectations surrounding contracts. For instance, the unspoken obligation to deliver goods in good condition or right to return faulty products can be grounded in local uruf. Second, social norms and ethics. Uruf plays a vital role in shaping social interaction and regulating behavior within community. It dictates what constitutes acceptable conduct in various circumstances, ensuring order and coherence within the social fabric. And last is the legal maxims and principles. Uruf can inform the development of new legal maxims and principles, reflecting the values and priorities of a particular society. This allows for the organic evolution of Islamic law, ensuring its continued relevance in the face of new challenges. However, the application of Uruf is not without its caveats. Determining the validity and extent of a particular custom requires careful consideration. First, the prevalence and acceptance. The custom must be widely practiced and accepted within the community, not just a small group. Mere isolated instances do not constitute valid Uruf. Second is the consistency and continuity. The custom should have a long-standing history and consistent application over time, demonstrating its root in the community, shared and understanding. And lastly, it should be non-contradiction with the Shariah. Uruf must not contradict the fundamental principle of Islamic law as laid out in the Quran and Sunnah. This ensures that its application upholds the core values of Islam. In conclusion, Uruf is a vital element of Islamic law, offering flexibility, context-specific interpretation, and a dynamic link between tradition and evolving needs of communities. While its application requires careful consideration and ongoing dialogue, its potential to ensure the continued relevance and adaptability of Islamic law remains undeniable. As societies evolve and new challenges arrive, Uruf will continue to dance its intricate steps with the law, ensuring that Islamic jurisprudence remains a living and vibrant force of justice and guidance.